Hey, Larry, we just talked about the basic, but very important deadlines on filing a patent. And you mentioned a provisional. Tell companies, maybe emerging companies, startups, someone who might not know how a provisional can be used and what it is. Uh, tell us how that can be used to perhaps protect patent rights.
Certainly, Jeff. So a provisional application doesn't ever get actually examined by the patent office. What it is essentially holds your place in line. If you're going to do a disclosure coming up, it's generally a good idea to file a provisional beforehand. Provisionals can be like a non-provisional, a regular patent application, but they tend to be quicker, cheaper, shorter, but they still can protect the rights as far as patents are concerned for your invention. And what a provisional does is it holds your place in line for 12 months. If you don't end up filing a non-provisional patent based on what you've talked about in your provisional within those 12 months, the provisional disappears and actually will remain secret. Nobody sees it except for the patent office database. And I like to split or talk about provisionals into three main categories. One is the proper provisional, one is the quick and dirty provisional, and the last one is the 11th hour provisional. A proper provisional resembles essentially a formal, normal, non-provisional application. Definitely want to work with a patent attorney on the provisional and think about what aspects of your invention you might actually get exclusive rights to in the future. The second one is the quick and dirty. They tend to be a little bit cheaper. It's definitely worthwhile to speak with a patent attorney on that. But if you have a deadline coming up soon, it's worth filing a quick and dirty provisional. That can include sketches on the back of napkins. It can include schematics and CAD drawings. And it doesn't have to be pretty, but it will protect your rights for anything in there. And the final kind of provisional I like to talk about is what I call the 11th hour provisional. It is not recommended that you do this if you have time or the resources to file either a proper or even a quick and dirty provisional, but it still provides some protection. And it's really the better than nothing provisional. And what I like to call an 11th hour provisional is, for example, if you have an academic paper that's about to publish and you don't have the time or the funds to get a better provisional prepared and filed, file that academic paper before it publishes, and that will protect your rights for whatever's in it. Or if you're going to present something on, for example, Kickstarter, whatever you're about to present on Kickstarter, just file that presentation as your 11th hour provisional. It will protect you and enable you to potentially file a patent in the future based on what's in there. So those are the main three types, and it's worth thinking about provisionals before you hit any of the triggering deadlines, the offer for sale or the public disclosure.